Good morning, everyone. I'd like to call to order the open meeting for Thursday, July 21st, 2022, and ask the Commission Secretary for information on today's agenda.
Each commissioner has independently reviewed the minutes of the open meeting of Thursday, July 14th, 2022, and each has informed me there is no need to discuss the minutes.
Move we approve the minutes of Thursday, July 14th, 2022.
Second.
All in favor?
Aye.
Agenda item 7 has been laid over today. Each commissioner has independently reviewed the agenda, and each has informed me there is no need to discuss the notices associated with agenda items 2 through 5, or the suggested minute associated with agenda item 6, accepting the applicant's 2021 fuel reconciliation application as filed, and finding that no refund is due to the ratepayers and no surcharge is owed by the ratepayers.
Move we approve the notice of investigation associated with agenda item 2.
Second.
All in favor?
Aye.
Aye.
Move we approve the notice of proceeding associated with agenda items 3 through 5.
Second.
All in favor?
Aye.
Aye.
And for docket 6630 FR 2021, I move that we accept the applicant's 2021 fuel reconciliation application and find that no refund is due to the ratepayers or no surcharge is owed.
Second.
All in favor?
Aye.
Aye. Okay, that brings us to agenda item 8, which is docket 9300-DR-105. This is related to a petition filed on May 26, 2022 by the Midwest Renewable Energy Association, asking us to open a declaratory ruling proceeding relating to whether third-party financed distributed energy resources are public utilities as defined in Wisconsin Statute 196.015A. Among other things, MREA would like us to open a declaratory ruling to examine these issues in particular. This petition doesn't give to us a specific contract. That'll come in the next item on our agenda. But what's in front of us today has nothing to do with the underlying merits. It's whether or not we exercise our discretion to actually open a docket. In their filing, MREA also asks that if we do decide to open a docket, that we do this as that the hearing be done as a paper-only hearing process. And so that is something that we can opine on if we choose to open a docket. So this is related to third-party financing that we've seen a number of times over the last couple of years. We've seen different types of agreements brought to us. There have been a couple of lawsuits filed, and this issue has come up in front of the commission multiple times, and I think it's starting to show up with more frequency. Again, the question in front of us isn't related to whether or not the underlying case has any merit. That would be left to the ALJ and the parties to develop the record and then bring it back to us. So I would open a docket to consider all or part of MREA's declaratory ruling request, and I would direct the ALJ to work with the parties to establish the process and the schedule for this docket. What I would want to see is I don't want this to languish, and I don't want this to turn into motions practice where we see all sorts of motions for interlocutory review and squabbles over evidence and discovery. And so I would like something back to us by December 1st. And then, again, we don't have to decide on it. We can choose to look at what has been brought together in terms of the record and the evidence, and we can choose to do nothing with it, or we can choose to take it up, talk about it, and potentially make a decision. And so I'm at alternative 1, and I would not go the paper-only route. I think it's important to have an open proceeding and the ability for both parties to examine witnesses if that's ultimately the route that the parties choose to go down. So I'm at Alt 1, and I would add that I would like something back to the commission no later than December 1st. Commissioner Noack?
Thanks. Yeah, I think there's no basis in the record to open a docket on this very generic request that they've put before us. It's a generic situation. There's, the petition itself lacks any specifics about any situation before us. This is rulemaking that they want us to do, which is ironic that many of the groups that are signing this petition and the other one, which were obviously coordinated, are often accusing us of doing rulemaking when we do things. So I just wanted to point out the irony on that. But there is nothing in this, and this goes directly contrary to the Wisconsin Supreme Court case, the Kohler case, which said that we should be deciding these. In fact, it said each case depends on its own facts and circumstances and must be tested by the statute in light of such facts and circumstances. We don't even have that here. Their petition lacks absolute merit to bring forward as a generic. We have rejected this many times on the one we've seen before. So and as for their request for a paper-only hearing, I agree with you. This, again, is a fact-specific situation, and I think it's improper to put a deadline on this to bring back before us. I know that there are other reasons to want to move this quickly through the system, but this should not be pushed through. Nothing has changed with these situations. The legislature's inaction doesn't invite us to act. There's nothing in Chapter 196 that says that, well, if the legislature doesn't act, we can act. That's a very dangerous precedent to set, and imagine all the things we could do. So this is a discretionary decision. The decision whether to open it or not is not reviewable, but I think by opening this and letting it go on, we've just invited ourselves to probably another lawsuit, just from the fact that there's nothing here for us to act on, and we would be doing rulemaking if we make a generic ruling on this. So I'm at no.
Okay. Commissioner Huebner?
Yeah, thank you, Chairperson. Thank you, Commissioner Noack. In this docket and the next one that we'll see, to me, both ask a specific set of questions related to a specific set of facts that they have laid out regarding our jurisdiction. And while the Commission has deferred action in the past, I think it is time to open these dockets and fulfill our responsibility to determine where our jurisdiction begins and ends related to these petitions. We, as an agency, have the competence to do that. The petitions, as written, provide substantial citations from case law for their arguments, and I think it's time to open this docket and the next and hear all sides of the issue and issue one or more decisions as the process may dictate. As you noted, Commissioner Noack, the legislature has introduced a bill. They have not acted. I would note that nothing in our decision to take action to open this docket, nor in whatever final decision or decisions the Commission may come to, prevents the legislature from acting on this matter or anything related to it. Senator Coles, for one, submitted comments in this docket saying that many of his colleagues wanted the PSC to weigh in. The public comments provided with the memo cited at least 7 states plus Washington, D.C. Commissions have acted on this question. So opening this docket doesn't make us trailblazers, but it is a reasonable step to provide guidance to parties who have explicitly asked for it in our area of expertise, the regulation of public utilities. So I would be at alternative 1. I think your proposal, Chair, is appropriate in that the process should play out. If it comes to the case where only paper is needed, fine, but we wouldn't limit that now. And then your concept to have it back to us by December 1st, I would accept that as well.
Okay.
Thank you.
All right. Want to make the motion?
Yep. In docket 9300 DR 105, the Commission, I move that we grant the MREA's request to open a declaratory ruling proceeding as discussed today.
Okay. I'll second that. All in favor?
Aye.
Those opposed?
No.
Okay. Moves us to agenda item 9, which is docket 9300-DR-106. This is a similar request, but this one is from Vote Solar, and it refers to the family project in Stevens Point as the specific case upon which they want us to weigh in, and for the same reasons that I indicated for the previous agenda item, I am again at alternative 1. I would not do a paper-only proceeding, and I would ask that information be returned to the commission no later than December 1st. Commissioner Nowak.
Yeah, and for the same reasons, I think we should not be opening a docket. While they did cite one specific case here, unlike the MREA one, I'm not fooled by the fact that this is going to be their template, and this is what they want to do, and will replicate it going forward. So I think we need to let the legislature again answer this question. The passage of time alone, just because more people write in and time has passed and the legislature hasn't acted, yet again, does not allow us to act where we shouldn't. We have said in other cases, in Sunrun and Wisconsin Solar Industry Association, that the commission believes the clarification of Wisconsin statutes regarding the status of such systems are more appropriate within the purview of the Wisconsin legislature. Nothing has changed in the fact situation. The only thing that's changed is the people sitting around this table, and that there are certain groups out there that want us to act before the end of the year. That's what's changed, and that is not a basis for us. That is not a reasonable basis for us to differ from our precedent that we've set before. So it is unfortunate that we're moving down this road, because this is in the purview of the legislature, and it is dangerous that we continue to do this. So I'm at alternative 3 again.
Just to be clear, nothing's changed for me either. So, I've voted in the past to open these types of dockets because I firmly believe that the statutes invest and place responsibility upon us as the agency to interpret statutes, specifically the provisions of Chapter 196. So nothing's changed for me. It has nothing to do with how many people are writing in or not writing in. I have been steadfast in the reason why I think that this agency is the appropriate and the only agency to be interpreting those statutes that empower our very existence. So I think it's important to make that clear.
I understand you believe that, but there are the commission precedent, and there are several cases where we have said that it is the legislature's decision to make this, and nothing in these petitions form a reasonable basis for us to detract from that. These are almost copycats of what we've seen before. So when we make a change in how we see things, we have to have a reasonable basis for doing so. And nothing has been laid out as to the reasonable basis, other than the legislature hasn't acted yet. And that's not a reasonable basis.
Okay, Commissioner Huebner?
Thank you both. I'm at the same spot on this. I would be at alternative 1. As I said before, to me, this is a specific set of facts. In this particular docket, there's a specific family project with a lot of specific contract language, and we could choose to address just that. There's also the question around sort of 7 characteristics that they identify. So we could look at that, more broadly in this docket as well. The proceeding will sort of dictate where that goes. But in both cases, in both situations, as you just said, Madam Chair, it's a question of public utility and does this apply? And interestingly to me, I read Kohler in leading up to this, which is the first time I've read it myself, and that was a situation where the commission identified a specific situation where power was being sold beyond the customer, and we attempted to fine them and say, you're a utility. And the Supreme Court ruled that we were wrong. The commission was wrong, that wasn't a utility, and a public utility means this. And they defined or they gave definitions of what their view of the public means. So we have that and many other cases cited in this petition and that we've seen in many other cases before, that create the boundaries of what is a utility. And I think it's our responsibility to use the statute and use those cases to make a determination based on this state of facts. And if that decision prompts action somewhere else or not, that's not in our control, but we do have the responsibility to give some clarity as to where our jurisdiction begins and ends. That's my view, and I've never voted on this before. So with that, I'm at alternative one.
Can I make one question for clarification?
Yeah.
When you were discussing the paper-only question,
Yeah.
you're not making a decision at this time, right? You're just saying you're not precluding,
No, I do not want paper only.
okay, so you are deciding it shall not be paper-only, even if the parties were to agree. Okay, and is that where you were as well, Commissioner Huebner?
I guess I can join that. I'm fine with that. I guess where I was coming in is basically not dictating that it has to be or not granting that it's paper only, but sort of letting the process play out. If they come to a stipulation of facts, like we saw, I think it was WPS Oconto, where they ultimately didn't need a hearing, you know, I'm fine if that plays out like
Right.
that. But I don't want to limit the proceeding either. So I don't know, Chair, if that's kind of where you are.
I guess what I'm trying to prevent is some sort of motion, 3 weeks from now because the parties can't agree. And so I'm trying to head that off
Yeah.
at the pass.
Yeah.
And I'm trying to give clear direction that we want a full record developed. Now, if it comes to pass that everybody agrees that there's a stipulation of facts and that all the parties in the ALJ agree that there's no need to have a hearing because nobody's going to have cross-examination, I'm fine with that. But I don't want this to end up being like what we've seen in some other cases where it's all motions practice, right?
Yeah.
So
Okay.
that's kind of my goal.
Does
So
that give
I
you
guess
what you
the
need?
best way to,
So then I think I think the motion was correct in that you were choosing alternative one
Yeah.
with the December 1st, no later than December 1st edition, and you're not choosing to limit it to the paper-only hearing, but you are, providing guidance here, rather than really an order point that it shall or shall not be paper.
that's fine.
Okay.
Yeah, as long as it's clear that,
Right,
the parties need to agree.
right,
And just get to building the record,
okay.
I guess was my point.
Yes, that's fine, I
Yeah.
just wanted to clarify that for both. So I think the motion for the first one is fine.
Okay.
You can make your motion for this one.
Okay.
So in docket 9300 DR.
I just
Oh,
have
go
one-
ahead.
Yeah,
Sorry.
I just wanted to add, I know where this is going, obviously, but your representation, I strongly disagree with Kohler. It was a specific circumstances. They presented a variety of different business models that they want them to go replicate. So the court said it has to be a specific circumstance. We don't have that. And if there's maybe one in the vote solar, which we would have to carve out and basically amend their petition. So again, we are taking a deep departure from our precedent for no reasonable basis. So you can go ahead with your
Yeah,
motion.
and I guess to me, it just depends on what's a case? What, is it a situation? I mean, this is a docket. It's a case, it's a state of facts that they've presented. So to me, that falls within a case. It doesn't, to me, have to be one project with this exact contract language. Because then you may be incredibly narrow.
Which is what the
That
court
if
said,
one
but-
lease term changes, does that, and so I think we're not there yet.
Right, and the
Yeah.
question in front of us is whether to open up
Yeah.
a DR or not. It has nothing to do with the underlying merits.
Right,
Right.
Which are
Right.
the basis of the Kohler decision. So
Right.
if we want to talk about Kohler and the questions presented in Kohler, then the appropriate way to do that is to use a new set of facts and compare that new set of facts against the precedent that's in Kohler. But that's not in front of us right now.
Correct.
So the first step is to open the DR. Then the next step is to weigh the legal arguments.
I think we're ready for the
Good?
motion.
Okay. In docket 9300 DR 106, I move that we grant Vote Solar's request that it open a declaratory ruling proceeding consistent with our discussion.
Second, all in favor?
Aye.
Aye. Those opposed?
No?
Okay, our last item on the agenda is Agenda Item 10, it's docket 9705-FG 2022. This item was laid over from our open meeting of last week, so I will turn it over to Commissioner
Yep.
Huebner.
Thank you both for agreeing to lay this over. In the past week, I've had the chance to review the memo again and Commissioner Nowak's handout in more detail. Where we began the discussion last week, Chair, you and I were fine with the changes in the staff's memo. I remain fine with those changes, but I also would accept the adjustment to item 1 from Commissioner Nowak, as you indicated last week. So I'm fine with that. And then I would not accept the changes to 2 and 3 and leave those as they were written in the memo. So that's
Okay.
where I landed.
Okay, and that's consistent with
Okay.
where I am.
Okay,
So I would
so-
accept Commissioner Nowak's Romanet 1 from her handout dated 7/14/22. And I would not accept any of the remaining edits in that handout, and I would incorporate the language that was in Commission staff's memo.
Right. Okay.
Okay.
Is that handout available on the website? Okay.
Can I ask why you don't want to, the decisions regarding settlements? Why
Right.
should that not be a full commission decision? Because that's what Romanet 3 talks about, is that decisions regarding when, how to settle, that we do enclosed, I'm clarifying that those are made by the full commission and not left to one commissioner. Is there a reason why you want to depart from how we've been doing it?
On that specific subset of that sentence, and Chair, do you have that in front of you? Okay. The part saying excluding decisions and settlements arising from defaults, which shall be made by the full commission. That has been our practice, and I don't have a concern with that subset. It's more the first half of that Romanet.
Right.
So go ahead, Chair.
No, I was just going to say that the other part significantly narrows the ability of the delegated commissioner to do the administration that has been done. So I read this as a drastic reduction in the authority of the delegated commissioner to act. I don't view this in any way, shape, or form taken away from decisions that are made by the full commission, which is why I agree to, clearly under Romanet 1, that's a clarification that is adding clarity and is adding, it's sort of encapsulating or codifying what we do in practice. Romanets 2 and 3 remove the ability of the delegated commissioner to do activities that delegated commissioner has been doing over the last couple of years. And I don't think that taking away that authority is necessary, nor do I think it's justified.
Okay.
Romanet 2 allows the commissioner to negotiate and execute any contract between OEI and other agencies or subrecipient. How is that narrowing the authority?
Because compared to the current
It's
delegation.
actually adding.
It's not, because you've removed the general descriptor that's there now. I need to get the current delegation up.
Oh, there it is. That's the one I need.
It's this one. Right. So Romanet 2, you added, for matters previously approved by or subject to final approval of the full commission. And that's not what's in the current delegation. The current delegation is negotiation and execution of any contract, agreement, or memoranda of understanding between OEI and other agencies or providers. So,
Well,
so
right.
that does remove responsibility.
Well, what I was trying to get at there is because there's going to be several pots of money that the agency could apply for, that it should be a commission decision about what those, because that could be a new subject area. It could be, I think it should be a commission decision over if we're going to start a new grant program, essentially. And that's what it says. And it still allows like them to try to go after it. But we, the commission, should be deciding, you know, let's say, for example, do we want to try to get $10 million for XYZ program? I don't think that should be left to the delegated commissioner, because then all of a sudden we get, hey, we have a new grant program. Well, where'd that come from? So that's where I'm trying to clarify that that's a bigger policy decision to chase after dollars.
And I don't agree with that. I don't agree with that characterization at all. The whole purpose of the 100-plus delegations that we have is to streamline our processes, to make sure that the agency is running efficiently. And when we delegate to commissioners certain responsibilities, that's why we put reporting requirements. And either one of us can ask the delegated commissioner, in this case Commissioner Huebner, for more information based on his updates. I don't agree with the premise that it has to be a full commission decision to decide to avail ourselves of federal dollars. I don't agree with that.
I think that's a major policy decision. There's going to be a lot of money coming from the federal government. They may decide, you know, states, you need to get into more transmission planning. Do we want to do that? I mean, I think we need to decide that, not one person. And back on number 3 again, it allows the delegated commissioner to negotiate, administer, and execute contracts from loans approved by the commission, except for settlements. So
It's totally different. It's, the current delegation is approval of new loans and decisions relating to the handling of existing loans, period. That's the current delegation.
Right.
Your proposal doesn't say anything about approving new loans on the delegated commissioner's own authority. It says that the delegated commissioner can negotiate, administer, and execute those that are approved by the commission. So it is, I mean, it's different. Obviously,
Yeah,
it's
it's
different, which
different,
is
yeah.
why you're suggesting to
Right, but-
change it.
if we're gonna be loaning out millions of dollars, it should be a commission decision.
And I think that that is the purpose of the program parameters that the full commission decides on, right? I mean, when we're talking about
No,
any
not
kind of
if we don't
program.
approve sub 2, because the parameters, the delegated commissioner can change the parameters by chasing after grant dollars that we don't agree upon.
And they would come to us, as is the case currently, and say, we have more dollars in this particular pot. Commission, please give us guidance on how you'd like to divvy up those dollars. And what programmatically makes sense right now for us when we are evaluating potential grant recipients. None of that is changing. None of that is going away.
Yeah, it is, but I'm not gonna, I'll withdraw my amendment if we're gonna go there.
Okay, so you're withdrawing your amendment.
Yeah.
Which puts us back to the original language that was in the memo.
Okay.
Okay.
And I'm fine with that.
Okay, so I believe that's alt 1
Okay.
Without the sub.
without, right,
Okay.
yep. Okay,
Okay, so in docket 9705 FG 2022, I'll move that we approve the proposed revisions to delegated item 128.
Okay, I will second that. All in favor? Aye.
Aye.
Those opposed?
No.
Okay. All right, that concludes our official business for today. The next open meeting is scheduled for Thursday, August 4th, 2022 at 10:30 a.m. So note, there's no meeting next week.
I move we stand adjourned until Thursday, August 4th.
Second.
All in favor?
Aye.
Aye. All right.
All right, so 7 we gotta hang on to.